Hello guys, my name is Gauri Bandre. I'm an intern at LEXIS and Company, and my topic for today's discussion is anticipatory bail. And in today's topic, we'll see how one can apply for anticipatory bail and what is the process being followed in application of anticipatory bail. So, to understand a little bit about the background, bail is provisional release of an accused in cases where the court is yet to decide the judgment. Bail can be broadly classified into three types. One is regular bail, second is interim bail, and third is anticipatory bail. So, what is regular bail? In cases where the accused is first arrested and then he can apply for a bail release by signing a bail bond. Now, a regular bail can be given in the favor of the accused in cases of bailable offences. Second is interim bail. Now, interim bail can be applied uh, before the application of either the regular bail or the anticipatory bail. It is provided for a very short period of time, and anticipatory bail is basically issued before the person is being arrested by the police officer in cases of an immediate release. So it is covered under section 438, and the main objective of it is to prevent violation of personal liberty of a person. Now it can be filed in cases of both bailable and non-bailable offences. It is to safeguard against arbitrary or groundless arrest. The basis on which the grant of the release depends on. First and foremost is nature and grievousness of the offence. Even before issuing the bail in the favour of the accused, the court will make sure that it understands the seriousness and the grievousness of the offence being conducted by the accused. If it feels that it is really irrelevant and it will cause certain consequences of the release, then it won't grant any bail in the favor of the accused. So it again varies from the case to case on the issuing of the anticipatory bail. Second is the applicant's possibility of fleeing from the justice. Now, in cases where the applicant is not from this country and there is mostly probability that the accused will flee from the country, in that case the court can deny the application. Third is previous case. If the applicant has certain amount of cases filed against him previously, then everything will be considered. The character of the accused is really important while granting of the anticipatory bail. Fourth is whether he can interfere or influence the ongoing investigation or not. In cases where the accused is very powerful in nature, or the court feels that he can probably interfere in the ongoing investigation, or corrupt the evidence which are being presented, in this case also the court can deny the application. It again varies from case to case. It is very subjective in nature if the court will grant the bail or not. If in case the court even consider to grant the bail, then again there are certain restrictions which will be imposed by the court. Restriction like to travel, there will be certain guidelines which will be provided by the court. It is mandatory for the accused to be present on every hearing of the court. And last but not least, if bail is denied, then the police can arrest the accused without any prescribed warrant. Now let us see how to apply for an anticipatory bail. If a complainant is accusing you and is falsely implicating you of something which you haven't done, then in that case you need to immediately consult a lawyer. After considering a lawyer, you need to narrate and provide each and every detail of the allegations to the lawyer, after which the lawyer will draft a sample, draft an anticipatory bail application, which will be further verified by you. You need to go through the whole application. You need to approve and sign wakalatnama and some affidavits. Also, you need to provide any materialistic evidence which will deny the allegations filed by the complainant. Next, this will be followed by the actual application of the anticipatory bail by your own lawyer. Now this whole process of approving, and the court will then send you a legal notice, this whole process will take 2 to 3 days. Now, the application can either be filed physically by the lawyer or via email. The court will then issue a legal notice, and the copy of your application will be sent to the police, after which the court will issue a date of hearing. In the date of hearing, the police officer or the investigating officer will be present and will have a reply for your application, uh, or will give a status report. So in that case, the police officer will describe the allegations and will state the importance of custody, and will, you know, emphasize on the seriousness of the offense and why it is important for you being arrested. The argument will take place, and after which the decision will be provided by the court. So the whole process can take about 7 to 8 days. If you are very much afraid of your immediate arrest, then you can apply for interim bail, or you can directly go to the sessions court, and where the uh, hearing will be stated within 1 day. So it again depends on the seriousness and how serious the or the gravity of the offenses. So this were some of the points which you need to know before the application and the whole process of application of anticipatory bail. I hope you liked this video. If you did like the video, do subscribe to this channel. Thank you.